everyone. I assume that the weather here is causing some lateness in people getting home and online, but I think we should go ahead and get started. So it is my pleasure to welcome you to the 6th installment of Operation Safe Spaces Family Law Seminar. This evening, our presenters are attorneys at law, Joan Byrne and Devi Ramnarine, who will be taking us through tonight's topic, which is the welfare principle. Just to give a little bit of an introduction, but I will also ask them to introduce themselves. Devi is a practicing attorney at law in Trinidad and Tobago of 30 years and is one of the founding members of the Family Law Association of Trinidad and Tobago, of which she has been a member of its executive committee from its conceptualization in 2012. Joan has been in private practice for 34 years and also a member of the committee of the Family Lawyers Association. As always, just a couple of quick housekeeping notes before we get started. Tonight's format will more be a presentation style, followed by what we hope will be a robust Q&A at the end. So feel free to jot down any questions while both Devi and Joan are presenting, or pop them into the chat and we will keep a record for the Q&A session. And my apologies for the background noise with the rain. All sessions are being recorded, as you know, so if you haven't done so already, please go ahead and complete the consent form and return at your earliest convenience. And as always, please don't forget to check us out on our social media pages on IG or Facebook at oss.246. So without further delay, I'll hand it over to Devi so that we can get started.
Great. Can everybody hear me?
Yes,
I assume so. Yes. All right. A very good evening to our hosts as well as our participants. As committee members of the Trinidad and Tobago Law Association, Family Law Association, sorry, my colleague and I were both very pleased and excited to accept the invitation to participate in this seminar, due primarily to the very noble objectives of Operation Safe Space, and also to embrace the opportunity to partner with our Barbadian counterparts in this exchange of ideas, information, and experiences. We have been asked today, as indicated before, to present on the topic of the composition and application of the welfare principles as it relates to children within the judicial system, with specific reference to matters involving domestic violence or domestic abuse. I know Robin asked me to do some introduction, but I think she did a good enough job. So I would forego that and get straight into my presentation if there's no objection. Right. I will start by stating my opinion that any discussion on a matter involving welfare of children, I believe, must commence with a clear understanding of what parental responsibility is. I know that may be going back to very basic principles, but I think it's necessary. This concept makes clear that being a parent creates a responsibility. And I'm going to emphasize this rather than rights. And it is that responsibility that we ask the courts to engage in when there's dispute into what is in the best interest of a child, between whether it is parties in conflict, whether it is in a custody or contact application. What the court actually has to do is place itself in the position of parent, in loco parentis, to make a determination as a parent would, what is in the best interest of the child. That kind of a discussion or that kind of determination is often complicated when there are issues of violence or domestic abuse that are at play. In the circumstances, when you are preparing an application, it would be very necessary to set out those circumstances so that the court is well informed of the issues that will affect a determination as to the welfare of the child. Now, first and foremost, a definition of parental responsibility in its bare bones is a responsibility of a parent to provide for the continuing welfare of a child. And that is to provide for the child's physical and emotional well-being. And you can already see that a child's physical well-being can be affected by abuse, and a child's emotional well-being is certainly affected by abuse. But that basic responsibility of looking after a child's physical and emotional needs can be expanded to include a wide variety of specific items, terms, etc. But at its core, if we break down all of the, all the attachments that can come with that, parental responsibility is the responsibility to look after a child's welfare and well-being. When a matter comes before a court for determination on an issue of custody and access or care, contact, whatever terms we use, and I realize that between Trinidad and Tobago, we do have a slightly different terms that we use. A judicial officer must therefore place the welfare of the child at the forefront. It is in fact mandated in the statute, which is at section 43(1) of your Family Law Act, to consider the welfare of the child as the first and paramount consideration. Every parent knows that just being a parent is not easy. And I suspect if we speak to members of the judiciary, they will also affirm that being a judge vested the responsibility of making custodial care, custody, and contact orders is also extremely difficult. And when we have to factor in elements of abuse that have been meting out either to the carer of the child or to the child himself, then that becomes an even more onerous task. And the judge must be careful to consider all that is relevant to finally make a determination that vests the child's welfare as its first and primary consideration. Assistance can be sought, of course, by judicial officers from many quarters. But at the end of the day, the judge must exercise that judicial discretion based on the facts and evidence presented before it. One must consider as well the applicable legislation, any case law, or other legal precedent. And sometimes the court can solicit the opinion of suitably qualified experts whose guidance and qualified opinions have been solicited in any particular case. It must be remembered that every case, every single case is different. There are no two cases that will come before the courts that are exact in its terms, in its facts, and the evidence presented, even in the way the evidence is presented, even in the way advocates present that evidence. So that in Barbados, in my consideration of your legislation, I see that the courts can call upon the chief welfare officer, even the chief probation officer, to examine the circumstances and to present reports. But we can also extend that in gathering information that is relevant to the welfare principle, extend that to include a report of a psychologist or a psychiatrist even, whose expert opinion is either solicited by a party or the parties jointly for the purpose of providing independent evidence to the court. When we, by way of overarching guidance, a judicial officer must look to the welfare principles. And before I move slightly off of that, the welfare principles can be garnered from. We have a legislation that says it must be the welfare of the child must be the first and paramount consideration. But how do we use that? Apply our facts to it to bring evidence before the court that will give the court sufficient information to make an informed decision. And this is where the welfare principles would have originated. What is it in determining that what is in the best interest of the child the court can consider? So even if our welfare principles are not codified, or they're not provided somewhere in the legislation as it is in the UK, or as it is in the family proceedings rules in Trinidad, we still can garner what are the welfare principles from the application of just in the ordinary course of things. When you are presenting a custody application, what should the court know? What should be presented to the court for the court to make use of in arriving at a decision? So your welfare principles will guide and focus the thoughts, hopefully, of the judicial officer, so that when the discretion is exercised with a clear objective of arriving at a decision that is in the best interest of the child, that you get, hopefully, the informed and appropriate decision that places the welfare of the child as the first and paramount consideration. So there are a couple of things that I want to get to before we deal with the listing of a welfare checklist, which is really an enunciation of the welfare principles. And this is just to tell you how important it is to have a judge consider, a judicial officer consider these welfare principles. It was found in a case of Eminem. It's a 1987 case, and we have Ms. Joan and I have actually had a list put in the chat of our intended citations. So Eminem, which is a 1987 case decided in the UK, the Court of Appeal determined that if a judicial officer arrived at a decision with on the issue of custody without running through a welfare checklist, it would make it easy for a dissatisfied party to appeal against that decision on the grounds simply that the judge has been plainly wrong. Plainly wrong in, of course, not addressing the specific welfare principles. The general principle coming out of that case, or in basic disputed contact cases, has been, and I mean, it's something that we all know as practitioners, that a child has a basic right to know its parents, his or her parents. I'm sorry, it just came out, it wasn't intentional. But there are an increasing number of cases in which there have been cogent reasons why a child should be denied that opportunity. And I was very struck by the terminology used in that case in Eminem, where rather than saying that a parent should be denied access because of his behavior, we are saying that in this case, it actually says that there's a good reason why the child should be denied the opportunity of knowing his or her parent. And I think that really shifts the focus onto the welfare of the child. We have to stop thinking about, because as advocates, we represent a party in the proceedings, and we often focus on what does my client want? What are the rights of my client? But in custody, contact, or access cases, we really need to shift focus, as the law requires us to do, into what is in the best interest of the child. Where will the welfare of the child best be served? What kinds of orders can we make to make sure that the welfare of the child is our first consideration, and we place the child's needs, emotional and physical needs, at the top of our list of things to consider. In Bried, which is a 1993 case, the idea of implacable hostility was also introduced. In that case, the court found that a cogent reason for denying access was the implacable hostility between the mother and her parents, and of course, the father of the child. The mother lived with her parents, so that the primary caregivers of the child were the mother and her parents. There was a considerable amount of disagreement between the parties. And because of that turmoil, the courts generally held that hostility was a type of, or could have been, a type of abuse. Whether it is meted out by the mother or the father, I don't want to get into that. but that abuse would have affected any order that the court made just because of the continuing and abiding and seemingly unresolved hostility that existed between the parents and other persons with whom the child had contact. In Re D, another UK case determined in 1997, the Court of Appeal held that implacable hostility could occur in cases for good reason, and also when there is no good reason or no good reason has been shown for that hostility. And in that case, there were good reasons because of the violence of the father towards the mother. So even if there is no violence extended to the child, remember our domestic violence legislation in both our countries have determined that the witnessing of violence is also an offense. So even if the violence has not been extended to a child, the mother the victim in the intimate partner relationship or husband and wife, etc., who is a victim of domestic violence, that domestic violence or abuse is also a factor that must be considered when you're determining the proper welfare of the child. In Re L, which is a case that was decided on domestic violence issues, where domestic violence featured prominently in that case, it was held that there was no presumptions against contact simply because of domestic violence. It was a factor that had to be considered, and a factor that must be considered, and it may be offset by the assumption that contact is a right of a parent. So that when you have a situation of domestic violence, here we have the court saying, and this is a 2001 case, the court saying that domestic violence will offset the presumption of equal contact, equal sharing, etc. Now, both my friend and I think in our discussions leading up to this seminar, in our discussions with Operation Safe Space, were, I think, surprised to learn that shared custody arrangements is a go-to position in Barbados. Because I think we have so many contested custody matters in Trinidad. And I'm not taking a side as to whether it's a better approach or not a better approach, because I want us to focus on what is in the best interest of the child who is the subject to any order made regarding custody access or contact. So I want to get straight into the welfare principles before I run out of time. So our family proceedings rules have detailed several welfare principles which have found their way, I think, into our rules, being a distillation of very many cases and very many, including the UK legislation, which lists 7 welfare principles to which they have asked the court to have regard when considering the welfare of minors. So a distillation of these welfare principles from case law, because I recognize we don't have that as a legislative component, shows that the principles falls into 2 broad categories, from which the checklist, which I will enumerate, has no doubt been developed. Those 2 broad categories are the requirements, wishes, needs, characteristics, risks, or any peculiarities of the situation relative to the child. So we consider what the child needs, what the child requires, what the child wishes to have happen, any peculiar circumstances surrounding the child, including ethnicity, the background of the child, etc. And the second broad category is the ability of the parent or other persons having parental responsibility for that child to cater to and promote the child's requirements, wishes, needs, characteristics, etc. Having regard, of course, to the situation, and to do so devoid of possible harm or with the minimization of risk to the child. So it's not just about the ability of so we're expanding now on parental responsibility. The ability of the parent to look after the needs of the child, fine, but we must also do so devoid of harm or the risk of harm to the child. And this is where I think a lot of the argument as advocates must come in to treat with domestic violence matters. So in where there is domestic violence in a relationship, we must be careful to make sure the judge appreciates that there is the possibility of harm to the child, or there has already been harm to the child. Right. So the welfare checklist comprises, well, there's a slight difference in the UK legislation as well as the Trinidad and Tobago family proceedings rules, in which they have separated out in Trinidad as a separate factor the cultural and ethnic background of a child. Whereas in the UK legislation is simply treated as one of the factors to consider in background and any other characteristics that may be relevant. So the Children's Act in the UK sets out as the welfare checklist or the welfare principles, the ascertain, and it is to be noted, of course, that this is in no particular order. It is listed because it is a list. But of course, you must select which is most relevant to your circumstances. And as an advocate, I would tend to want to file my affidavits, etc., based on what is the most relevant circumstance or that I want the court to know. But certainly when I'm drafting or devising my plan or my strategy, I will include a discussion or evidence treating with each of these matters in the welfare checklist. So by way of just dealing with the list, the first matter I would want to deal with is the ascertainable wishes and feelings of the child's concerned. Now, this really is what the child has said he or she wants to happen, or if he or she is considered old enough or mature enough to reach a decision or to express that opinion. In the 1992 case of Bried, the court had to consider the wishes and feelings of a child and to consider, in that case, the court was required to consider the wishes of a 16-year-old anorexic girl who was actually refusing medical treatment. And felt that with one, if the child remained with, this was a case where the court was considering putting the child into care outside of the parents, but the principles remain. What was in the best interest of the child? If we took charge of the child and put her in an institution, we could probably force treatment on her, whereas the parents may not have been so inclined or to treat with it on a private basis. So we also have to consider what was the effect of that child's opinion or stated wishes on the judicial officer who is deciding the case. So there are several things we have to look at when we're considering ascertainable wishes and feelings. Of course, I've indicated before whether the child is mature enough to have expressed that opinion, whether the child is old enough, and of course, whether they can express that opinion. And I'm going to the expressing the opinion now, because it is here that we have to consider whether the child has been coached, whether the child has been threatened, whether the child feels that he or she is being made to take sides, or whether pressure is being exerted on the child. And all of that can have a root cause in domestic violence in the relationship, whether witnessed by the child or whether expressed to the child directly, or whether that abuse had been meted out to the child himself. We also have to consider here the issue of parental alienation, because if a child is being, if the attitude of a parent to a child is to keep that child away from the other parent, then that too, if there is no good reason for doing so, may also be considered abusive. Because again, remember, it is a right of the child to have and know, to have a relationship with and know his or her parents. Right. Lord Simon of Glaisdale, who participated in the debate on the UK Children's Act, which is a debate that spanned more than a year and a half in the United Kingdom in 1988, had these comments to make. And I feel that it is prudent to list them so that they can be more clearly understood. He indicated a child is easily influenced, and it is not in only this branch of law that the law takes cognizance of that fact. When a child complains of a sexual assault, a judge will always warn the jury that it is unsafe to act purely on the say-so of a child, because children can be easily influenced. Time and again, adjudicating bodies in this field have come across cases where one has felt that the wishes of the child as expressed, however it is expressed, reflect deeply the feelings of the person who has had custody of the child. And time and again, one is told that a child has an invincible repugnance to another parent. That always puts an experienced judge on warning, because it is not really natural for a child to have an invincible repugnance to a parent. Indeed, the whole social background that has been fostered encourages children to love and respect both parents. As I say time and again, one finds a plea of invincible repugnance to a parent who is a non-custodian. So in drafting or crafting your application, to appeal to a judicial officer to take into account circumstances of abuse that ought to affect or change the dynamic of the shared custodial arrangement. Of course, the wishes of the child are relevant, so long as the child is mature and old enough to express that opinion, but you also have to look towards convincing a judge that the child has not been coached, that the opinion or the feeling or the wish is genuine, and that it is done, that the expression of the child or the wishes of that child has not been subject to any kind of threat, which of course all of that would be abusive. Right. So moving right along to the second one, which is the child's physical, emotional, educational needs, and a consideration of who can best provide for those needs. So that would also include things like accommodation, material advantages, financial provision, whether the child is allowed to express himself openly, whether the child will be allowed to go to the school that was decided by the parents or most convenient, etc. So issues such as with whom the child has a bonded relationship, the impact of any order and is likely to have on the child's sense of security, and the importance of maintaining status quo are also considered under this head. There is, of course, the importance, and I stress again, of a child knowing both parents. And you would see that I have included a citation for a case of Bried, which is a 2008 case, where a court of appeal confirmed that a court can, where appropriate, make orders that require parents to firmly indicate certain things to children. For example, these children had been raised not knowing, in this case, the children had been raised not knowing who their natural father was. And the court in the UK indicated that the mother must, not shall or must, make that information available to the children. And you would see that that becomes relevant because all of these welfare principles are kind of tied up together. So that becomes a little more relevant where we talk about the cultural and ethnic background of children. But it's also relevant here because that parent could then have been approached for providing for the physical needs of the child or the educational needs of the child once that information was known. The next item I would like to get to is the likely effect of any change in circumstances on the child, of course. So we have to consider under this head, what is likely to change once an order is made in a certain way? Is a child then going to be required to deal with another adult in the household? The child's life, another person being introduced into the child's life, whether it is another husband or wife or a new cohabitee, etc. Whether it is going to require a move to other accommodation, a new school, or even relocation to another country. And that relocation issue is a serious issue, but for another discussion. That change in circumstances can be to have the child in an environment, particularly in the shared custody arrangement, because the child may not now have the protection of a parent who had been the protector in the relationship when the parties lived together as a unit. So where you have the removal of that protector from the child for, let's say, 2 weeks out of every month in a shared custodial arrangement, then you have to consider what is the effect of that on the child. And that has to feature in any evidence that is being supplied to the judge so that that can find its way into in the thinking of the judge to feature in the decision that is made. Also, when you're treating with this head, you may also need to be channeling yourself into the future. Because remember, it is any likely change. So you have to think in terms of what can happen in the future and what can affect the child and have an effect on the child's welfare going forward. That's just a matter of note. Of course, then we consider, as we do in Trinidad, the cultural and ethnic background. And there is a case that I have cited, which is, Repeat. It's a 1999 case in which the House of Lords held that Roman Catholic foster parents of a Down syndrome child born to Orthodox Jewish parents could remain with sorry, I just lost my place. Could remain with the foster parents rather than being relocated to the child's natural parents. The House of Lords confirmed that the benefit of the child continuing to be brought up by foster parents to whom she had become greatly attached outweighed the benefit of her being brought up as an Orthodox Jew, as she did not have the capacity to understand fully or appreciate her Jewish heritage. In effect, this case has added a consideration of religious background to a checklist of matters to be taken into account when assessing the welfare principles. So of course we have in Trinidad a melting pot and very diverse cultural and ethnic and very strongly so held beliefs, religious beliefs, etc. And it is a factor, for example, where we have a mixed Hindu marriage couple who have now separated, and we have issues of whether parties will remain vegetarian, or what type of meats the child will eat, or what prayers the child will say, or what mosque or what temple the child will attend, etc. Those things become relevant, of course, after the breakdown of the relationship. And of course, we have to look at those circumstances again, because I'm bringing it back to the abuse principle of whether that may be being forced on a child, or whether the enforced attendance on a religious event or cultural event featured in the relationship. So that ought to be made known to the judicial officer, and also factor into the decision ultimately at the end of the day. I want to move on now to the next one, which is a very easy one to understand and to apply to any circumstance. The age of the child, the gender of the child, the background, and this is where we have a little repetition because we've also dealt with ethnic background before, but this is more expansive. And any other characteristics of the child that the court may think relevant. So of course, this is the part of the welfare checklist where you simply put all your junk in your trunk, right? So anything that you consider relevant, or anything that you think the court should consider relevant, should be put in when you are considering this part of the welfare checklist. Of course, there are certain things to guard against. When it comes to the care of a child of either sex, there is to be no presumption existing in the favor of one parent or the other. I also opine that courts ought not to be keen to endorse gender biases when dealing with care and access cases. They may exist pressure groups that function to bring awareness to feelings of anti-father biases or pro-mother assumptions. And when treating with these issues, we as advocates should try to dissuade our clients from promoting that. It is unhealthy. And of course, a judge is supposed to shed all personal biases to make decisions that are solely founded on the welfare principles. Right, other issues which may be relevant under this head relate to the bringing up of the child in circumstances that could be said to be slightly unusual, and hence which might have a potentially negative effect on the child's welfare. For example, where a parent belongs to a religious cult, or wishes to have the child live with them off the grid, or not to be enrolled in school after age 12, or where we have parties who may consider female children to not be educated or as educated as male children, or not having that requirement. So all of these issues can come into play, which again is also can be considered abusive. And of course, you could structure your case to make that a really big issue in your case. I do recall, and I'm going to go into a bit of my personal experience here as an advocate, representing a man who wanted to have custody of his male children, but not his female children. And the reason why he wanted custody of his 2 sons as opposed to his 3 daughters was that his daughters were too expensive. Their needs were going to be too much. And you had to look after your girl children in the way you didn't have to look after your boy children. Of course, I had a very difficult time representing this client because I felt his views were outmoded, otherworldly, etc. But at the end of the day, the judge made a determination that she was not going to split the children. That was the focus of the decision. The children were not going to be split, and both parties were going to have an arrangement where the children had access to the father, but were primarily in the care of the mother. The other 2 issues are interrelated. The other 2 welfare principles are interrelated, but I will try to treat with them as separately as I can. I don't know if somebody could tell me how I'm doing on time. It's about 45 minutes now. Yes? Okay. So the two other principles are any harm which the child has suffered or is at risk of suffering. And I feel that here is where our real issue about the violence to children or carers becomes relevant. Where a child has been neglected or physically or sexually abused, or it is feared that there's a risk of such abuse, we must invest in a consideration of the balance of harm or the application of the test or the balance of harm test, where the court is required to examine the harm that the child has suffered or the harm that the child is at risk of suffering in the future. For that definition of, or that application of that test, I would like to define harm as being ill treatment or the impairment of health or development. Of course, a lot of other things can come into play into that risk of harm. But if you really think about it, abuse falls into that: abuse of the carer, of the child himself, physical abuse, sexual abuse, emotional abuse. All of that can fall into that definition of harm. And the court would be required in adopting this test or taking this test to weigh up the potential risk to the child in the environment with the person responsible for causing that harm or who is likely to inflict that harm at some point in the future. In these circumstances, you might have to put in evidence in the case of actual abuse that has occurred in the past. You may also want to put in evidence of what triggers the abuser has or that have been identified. And you would also want to indicate to the court in your evidence what is the effect on the child when these things happen, because it is to that the court, having been informed of the circumstance, would also need to understand what effect it has on the child. So this particular criterion will require the court to examine allegations of domestic abuse and requires the court to consider if the child's de facto custodian or the child himself is likely to suffer harm. Some of the cases actually move away from harm and say significant harm. But I think harm, when you are considering the application of the welfare principles, it doesn't need to go to significant harm, but I think harm is sufficient. So the child himself is likely to suffer harm attributable to the other parent or other party to the application if access or contact is maintained, or even if shared custody orders are made. So here too, even though we are considering welfare principles as it applies in custodial cases or access cases, contact cases, etc., I would also invite all the advocates to consider that we must also put before the court the likely effect on the custodial parent or the de facto custodial parent if they have to continue to be subjected to the abuser. For example, in the handing over of a child, if that is to be done, every week, and in what circumstances that is to be done, and to also indicate in your evidence the likely effect that is to have on your client, because that is also going to affect her ability to properly cater for the welfare of the child. If she's fearful all the time when she has to have contact with the abuser, then of course that is going to have an effect on the child. Does the harm or the risk thereof warrant the restricting of making of supervision orders for abusive parents, and where such a finding has been made, to have and maintain contact with the children? So we've treated now with the victim and the effect on the child or the risk of harm, etc. But we also have to consider, what do we do with this information? And there is one matter that has been included in the UK legislation, which has been omitted from our family proceedings rules, which is the types of orders available to the court to treat with the welfare, to treat with custodial access and care orders. And I will get to that last, but I want to mention it here now because there is something that we as advocates normally see when we are treating with issues of abuse, particularly issues of physical and sexual abuse. Where in the early stages of an application, we say it is better to err on the side of caution than, of course, to expose the child to potential harm. And it is a good principle, I think, to adhere to, rather than initially going to a shared custodial arrangement when there are cogent reasons to deprive the child of the opportunity of a shared arrangement, that we must act cautiously. Right? So that, and I raise this here because, and to connect it to one of the others where we treat with the background and the needs of the child, etc., that we have to also consider that these types of issues may also have an effect on occupational orders for occupation of homes, to remove parties from homes, etc., which of course, again, is also linked with the Domestic Violence Act. I want to move on quickly to the ability of and capability of parents and other relevant people to whom the court considers the question relevant of meeting the child's needs. So that's a roundabout way of saying that we are assessing the parents and their ability to cater to the child's needs. And here, again, it is very relevant to set out evidentially to your court why the other party, who is the abuser, is incapable of meeting the child's needs. Again, I go back to parental responsibility. If that abuser is given shared custody of a child, is it that he is going to now be deemed capable of meeting that child's needs? Certainly, he is not going to be able to emotionally care for the child in a way that is not going to bring harm or risk of harm to that child. So here again, we tie in the welfare principles, one to the other, because a parent, as opposed to all the other welfare principles which relates to what the child needs, here we actually have to assess, is the parent capable of meeting that need? Here we have to consider as well, going forward, whether we want to consider rehabilitation of the abuser, if there's any admission of the abuse, if the parent is willing to seek that intervention to address the situation so that they can, in some point in the future, become capable of tending to the welfare of the child or of meeting the child's emotional and physical needs. I want to bring something to the participants' attention. For example, in many years ago, it would have been unthinkable for a court to award care and control of a child to a homosexual father. Of course, that has long since gone by the wayside, but the consideration of the ability to care for the child is what has replaced it, rather than this particular circumstance of the father's sexual orientation or persuasion. So if we apply that to our current, our situation where we are considering, in many years ago, domestic violence or the ill treatment of women or the treatment of women as subservient in homes, which is abusive, that led to certain types of orders or custodial orders. We have to set aside that kind of thinking, and we have to now treat with the welfare of the child as being, again, and the legislation says it so clearly, as first and paramount consideration. I move to the types of orders that are available to the court. Now, again, in our preparatory sessions with OSS, we were asked to treat with this specifically. Because in Trinidad, we do have a range of options available to us when we bring this kind of information to the court regarding abuse, whether it is physical, sexual, or emotional abuse. In a dispute, in a custodial dispute between mother and father, we have available to us orders that deal with the supervision of access arrangements with children. We can have, now that we have the gender-based violence unit in the police service, we also have circumstances where the child can be handed over to a parent in the presence of a police officer. We also have a circumstance where we can have a family member appointed as a supervisor, so that supervision can be done in a family type environment, in a home where the child has access to all its comforts, etc. But there is still somebody who is overlooking and can take charge in the event that there is a risk to the child or potential a situation developing, etc., even for the carer of the child. That supervision has also been done within the family court. We have an infant's room, we have a children's room to cater for different ages of children, where a court officer actually treats with the supervision, and in the event that there's an issue, makes a report of that visit available to the court for the court independently, so that the court can have can be fully informed in relation to those visits. Now, that is not to say those are not without problems. All these types of orders are going to have issues, and it's usually, we make interim orders first, we might expand them later, then we have to contract them after. But I think at the end of the day, it is most important for us to consider that in cases of abuse, where particularly when it has been prevalent and has been experienced by the child, either by witnessing it or experienced physically one-on-one, it is important that the court simply not go to a shared arrangement, but that by your advocacy and the evidence you present, you can persuade a judge that is maybe a supervision order is necessary, or maybe less access is necessary, or in certain cases that it should be suspended altogether. And I think it should be suspended only in very rare circumstances, but that can also be a situation that arises. So I've dealt with all of the welfare principles. I know that my friend is going to treat with certain of the legislative instruments that are available. And I know that Robin did ask that we suggest a break for maybe 5 minutes before we continue. Robin?
Thank you, Devi. Yeah, we'll take a quick, let's say, 5-minute break. So that puts us to 6:33. Feel free to get up, move around, get a glass of water, and we'll be back shortly. Thank you, Joan, as you're ready.
Yeah, thank you. Thank you to Operation Safe Space for this honor and opportunity to present to you all this evening. And thank you participants who have logged on for our session this evening. Robin gave me a brief introduction, but I just would like to add that my practice is mainly family law and to a small extent civil and probate law. I love helping people, and I guess that's why I enjoy being a family lawyer. So having said that, I'll move right into the presentation. My aim in today's presentation on the welfare principle is to provide an overview of the laws of Barbados as they exist now, and to examine the UK position through the case law, legislation, and practice directions on the area. The presentation is not meant to be a law lecture, but rather to provide some food for thought on the area, which can hopefully be used to initiate changes in the legal landscape in Barbados. The welfare principle is certainly provided for in the Barbadian legislation. The legislative net is wide enough to catch the perpetrators of violence inflicted on children as well as adults. I will attempt to briefly set out the relevant sections of your legislation which deal with the welfare principle. So first of all, I will refer to your Family Law Act, Chapter 214, under Part 5, the welfare, under the rubric Welfare and Custody of Children. Section 41 deals with the welfare principle. It states where the welfare of a child is relevant, the court may, of its own motion or upon the request of a party to the proceedings, make an order directing the parties to attend a conference with the chief welfare officer or chief probation officer to discuss the welfare of the child. And if there are differences between the parties in relation to matters affecting the child's welfare, to attempt to resolve same. Section 43 goes on to talk about in proceedings relating to the guardianship or custody or access to children of a marriage or union, the welfare of children is the first and paramount consideration. Your court will not make an order in respect of the guardianship or custody or of access to a child who is 16 years and over, contrary to the child's wishes, unless there are special circumstances. The court shall discharge or vary an order in respect of the guardianship or custody of or access to a child who is 16 years and over, if in accordance with the child's wishes, but may refuse to do so if it is undesirable by reason of special circumstances. Section 44 of the Family Law Act provides for separate representation of the child in custody, guardianship, maintenance, or access matters, all in keeping with the welfare principle. And I must say, when Devi and I looked at your legislation, we were quite impressed with your Family Law Act. We noted that you had a lot of legal issues codified in your law and propositions of law, which we would normally have to go to the case law to establish in our cases before the court. Your Minors Act, Chapter 215 at Section 8, says where in any proceedings before the court, the custody or upbringing of a minor is in question, the court in deciding that question shall regard the welfare of the minor as the first and paramount consideration. Specifically, under your Domestic Violence Protection Orders, Chapter 130A, which is amended by the Domestic Violence Protection Orders Amendment Act in 2016, under the definition section, a child is any person under 18 years of age who is not married and is considered to be in a domestic relationship by virtue of continued residence or a relationship of consanguinity or affinity with a perpetrator or victim of domestic violence, and includes an adopted child, a stepchild, and a ward. Child abuse is defined as meaning any act of domestic violence perpetrated against a child and includes causing or permitting a child to witness, hear, or be exposed to acts of domestic violence. Domestic violence is defined as meaning the willful infliction or threat of infliction of harm by one person in a domestic relationship upon another person in that relationship and includes child abuse, emotional abuse, financial abuse, physical abuse, and sexual abuse. Interestingly enough, emotional abuse includes withholding from a victim access to the victim's child. Financial abuse means the exercise of control by a perpetrator over a victim's access to financial resources, the effect of which is to hinder the victim's financial independence or ability to support a child. Under your act, your domestic violence as well, a victim of domestic violence can include a child. Section 11A of this act gives the police have to ensure the welfare and safety of children on premises when responding to a domestic violence complaint. And under Section 11B, the police can issue an emergency protection order, and in determining whether to do so, the police shall consider the welfare of any children residing with the perpetrator or the person at risk. So I am not certain if your police officers are sensitized to their duties under this legislation in terms of dealing with a domestic violence situation as it affects children. You obviously have the legislation in Barbados to protect children in the scenario of domestic violence in your country. And the courts have a duty to protect children, not only the adults. Moving on, I just wanted to refer to a landmark case where the welfare principle is clearly defined and established in the UK case of House of Lords decision of J versus C. It's a 1970 House of Lords decision. And I know that all of these citations are in the chat. In this case, the law lords in their wisdom were persuaded to allow a 10-year-old boy to remain in the care of foster parents in the United Kingdom, as opposed to being with his biological parents in Spain. The child was ordered to be brought up in the Roman Catholic religion in the United Kingdom, even though his foster parents wanted him to be brought up in the Church of England faith. His biological parents were well off and unimpeachable. You could not find any fault with them, according to the law lords. And just in quoting from Lord McDermott and Lord Pearson in dealing with the welfare principle, they stated that while there is now no rule of law that the rights and wishes of unimpeachable parents must prevail over other considerations, such rights and wishes, recognized as they are by nature and society, can be capable of ministering to the total welfare of the child in a special way and must therefore be preponderant in many cases. The parental rights, however, remain qualified and are not absolute for the purpose of the investigation. A growing experience has shown that serious harm may be caused even to young children by a change in custody. I do not suggest that the difficulties of this subject can be resolved by purely theoretical considerations, or that they need to be left entirely to expert opinion. A child's future happiness and sense of security are always important factors, and the effects of a change in custody will often be worthy of the close and anxious attention which they have received in this case. And finally, just a quote from Lord Upjohn: "The natural parents have a strong claim to have their wishes considered as normally the proper persons to have the upbringing of the child they have brought into this world. It is not, however, a question of the onus being on anyone to displace the wishes of the parents. It is really a matter for the judge, bearing in mind the rule laid down by Justice Eve in Re Fane." So therefore, why I have quoted from this case is to just show that, how the welfare principle has been established from 1970 as a very important factor in considering custody and access applications. And the welfare principle has been, my friend has referred to the checklist, which is enshrined in the Children's Act in the 1989 UK Act. In Trinidad, we are very fortunate to have this checklist in our Family Proceedings Rules 1998 as amended. It is actually set out in the overriding objective in part 1 of our Family Proceedings Rules. And I will just briefly, I don't want to go into detail because my friend has gone into detail, but the checklist as set out in our Family Proceedings Rules gives first and paramount consideration to the welfare of any child of the family where any question relating to custody or supervision of or access to that child is concerned. And it includes, it seeks so far as practicable to encourage better relationships between parents and others in caring for the child, and in particular, communication and cooperation with regard to the parenting of such child. Also improving and developing the relationship between each parent and others and the child. Now, I don't know whether in Barbados, you do have co-parenting counseling available for parties in custody and access disputes, and that is something which we do have in Trinidad, and it has proved very helpful in some circumstances, in some cases, of course, in fostering a better relationship, first of all, between the parents, which then leads to a better relationship between the parents and the child, or the child's relationship with the parents. So I just wanted to now turn to a recent United Kingdom case. It is a High Court decision, a father versus a mother, and it is in the chart, the citation. It is the Justice Joanna Vincent in that matter. She has really dealt very, very well with the considerations, especially in a matter where a parent is seeking a contact order, as it is referred to, or access, as we refer to that type of application. It is an application for a contact order of a 7-year-old child born to unwed parents with a history of domestic violence between them. The court set out at page 5 of its judgment the law in England with respect to the welfare principle. The judge at paragraph 20 of that application said, in determining the father's application for access under section 1, subsection 1 of the Children Act 1989, of course, the children's welfare must be the first and paramount consideration, and the court's welfare assessment must be informed by an analysis of the factors in the welfare checklist. Now, Devi has gone through an analysis of those factors for you. The court also said at paragraph 21, further, section 1(2)(a) provides a presumption in favor of both parents being involved in a child's life, unless that is proved to be contrary to the child's welfare. That involvement need not be equal and may be direct or may be indirect, so that contact or access does not have to be direct access or access in person. You can have access with respect, you can have access orders which are by virtue of video calls or sending cards or sending gifts, etc. To the child, and not a direct contact order as was done in this case. Now, the court in this case took into account Practice Direction 12J of the Family Procedure Rules in 2010 in the UK. The court must take into account a number of factors when considering whether to make a child arrangements order when domestic abuse has occurred. When deciding the issue of child arrangements, the court should ensure that any order for contact will not expose the child to an unmanageable risk of harm and will be in the best interest of the child. The court also went on to say, in the light of any findings of fact or admissions, or where domestic abuse is otherwise established, the court should apply the individual matters in the welfare checklist with the reference to the domestic abuse which has occurred and any expert risk assessment obtained. So I think Devi did mention a psychologist report, which would be an expert risk assessment in this case. In particular, the court should in every case consider any harm which the child and parent with whom the child is living has suffered as a consequence of that domestic abuse, and any harm which the child and parent with whom the child is living is at risk of suffering if a child arrangements order is made. The court should make an order for contact only if it is satisfied that the physical and emotional safety of the child and the parent with whom the child is living can as far as possible be secured before, during, and after contact, and that the parent with whom the child is living will not be subjected to further domestic abuse by the other parent. And I gather that this is of some concern in Barbados, where you do have a scenario where the victim of abuse has to allow access to the perpetrator of violence, the other party, and that can cause a serious risk of harm to a child in those circumstances. And of course, a risk of the victim being further abused by the perpetrator during those access visits. The case also went on to analyze further in every case where a finding or admission of domestic abuse is made or where domestic abuse is otherwise established, the court should consider the conduct of both parents towards each other and towards the child and the impact of same. In particular, the effect of the domestic abuse on the child and on the arrangements where the child is living, the effect of the domestic abuse on the child and its effect on the child's relationship with the parents, whether the parent is motivated by a desire to promote the best interests of the child or is using the process to continue a form of domestic abuse against the other parent. And I think we all can identify with this scenario. The likely behavior during contact of the parent against whom findings are made and its effect on the child, and the capacity of the parents to appreciate the effect of past domestic abuse or the potential for future domestic abuse. Now, I'm still reading from this case, a father and a mother. An order which effectively prevents a father from seeing his child is one of the greatest significance and would have potentially serious and lifelong consequences. The judge said, I remind myself of the case in Re-C, direct contact suspension, paragraph 47, in which the Court of Appeal summarized the approach to parental contact as follows. Contact between a parent and a child is a fundamental element of family life and is almost always in the interest of the child. Contact between parent and child is to be terminated only in exceptional circumstances where there are cogent reasons for doing so and where there is no alternative. Contact is to be terminated only if it will be detrimental to a child's welfare. So, for example, just to digress a bit for situations that I have come up against in practice as a family court advocate, there are a lot of circumstances with unmarried young parents that I have been dealing with on a regular basis, and they split up and you have a young child caught in the middle. it normally, in my experience, the women in particular, young women, tend to hold on to this child and feel that this is their child. The father, okay, yes, he's the biological father, but fathers are not entitled to equal access or equal time with this child. And I think the courts, or the approach of the courts in Trinidad now, is in the family court judges, is that no, which they tend to follow the guidelines as established that I've been reading to you, that both parents are entitled to equal access, and cutting the contact between a child and a parent, there has to be something that is going to be seriously detrimental to that child, or a serious risk of harm to that child, before the court will actually do that in Trinidad. And we actually have orders now where whether babies are being breastfed or they are less than a year old, fathers are having contact, more and more contact with their children, very young babies. The judge also went on to state there is a positive obligation on the state and on the judge to take measures to maintain and to reconstitute the relationship between parent and child. In short, to maintain or restore contact. The judge has a positive duty to attempt to promote contact. The judge must grapple with all of the available alternatives before abandoning hope of achieving some contact. He must be careful not to come to a premature decision, for contact is to be stopped only as a last resort, and only once it becomes clear that the child will not benefit from continuing the attempt. The court should take both a medium-term and a long-term view, and not accord excessive weight to what appears to be likely short-term or transient problems. The key question, which requires stricter scrutiny, is whether the judge has taken all necessary steps to facilitate contact as can reasonably be demanded in the circumstances of the particular case. All that said, at the end of the day, the welfare of the child is paramount, and the child's interests must have precedence over any other consideration. I think in talking to Robin and Marsha, I got the impression that supervised access orders are not the norm in Barbados. They are quite common in Trinidad, where you do have supervised access, well, in this case, at the home of the victim, where the access may be supervised by a relative, in the absence, of course, of the victim, and the perpetrator can have access to his or her child. And then you have a situation where in the family court, prior to COVID, where we do have a children's room, I think Devi might have mentioned this, where you did have supervised court access in certain circumstances, where the court thought it was a risk to the child to have access outside of the court supervision. The analysis of this judge on pages 12 to 14 is very useful. This is, again, I'm still on the A&A case with respect to the welfare checklist. The judge at paragraph 71 onwards deals with the impact of parental conflict on the child, in this case, a 7-year-old girl. The father had subjected the mother to abusive behavior, which left her anxious for her and her child's physical and emotional safety. The judge said, I accept the analysis of Mr. Kent and the opinion of Dr. Rawala, who was an expert. The mother's feelings of anxiety and trauma related to the father and prevented her from co-parenting with him. The ongoing hostility from him towards her during these proceedings has only served to exacerbate her anxiety. The impact of direct contact arrangements on the mother's emotional well-being and presentation is likely to be significant, and is likely therefore to affect her ability to parent for her daughter and to reassure her that she can keep her safe. While the father remains so hostile to the mother, she remains traumatized by her experiences, and he does not acknowledge any need for change. The father thinks that his impact on R is that there is no hope that while R is a child, she will ever feel she can be supported simultaneously by both her parents. In fact, she is more likely to have to take sides and possibly witness conflict. The mother finds any form of interaction with the father to be extremely stressful and provoking high levels of anxiety. This litigation has been protracted and needs to come to an end. The expert suggested supervised contact and then a review, but it was not clear what needed to happen. An open-ended plan where the father is not intending to embark on any form of work or recognize the need to change means that the parents would be set up for future conflict. The father suggests that after initial sessions of supervised contact, it could move on to unsupervised contact or stay in contact with the child. The mother would have to negotiate with him. It is a lot to ask of her, where he has been dismissive of her concerns as absurd, fabricated, and malicious, and where he does not accept that there's any need for him to make changes in his approach, but is highly critical of her and considers that all is needed is for her to do as he asks. And I think we all can identify with this type of situation. The judge went on to further elucidate her considerations with regard to specific matters at paragraph 37 of the practice direction. This is the practice direction which I referred you to earlier, practice direction J12. With respect to specific matters at paragraph 37 of the practice direction, I have considered the impact of continued parental conflict upon R, that is the child, and the risks that this would pose to her relationship with each of her parents. Her mother's ability to care for her would be impaired, and her feelings that in pursuing a relationship with her father may cause her mother unhappiness or anxiety are likely to be burdensome on the child. Because of the father's personality, the intensity of his emotions, she may be subject to feeling overwhelmed, confused, constrained to follow his lead, or responsible for his emotions. She is at risk, that is the child, of being exposed to high levels of negativity with which he sees her mother, and her parenting could be undermined as a result, and she could feel conflicted. I accept that the father is motivated by a genuine desire to play a part in his daughter's life and to introduce her to family, culture, and heritage. However, in pursuit of this goal, I am concerned that he has sometimes lost sight of her needs and that he does not recognize that he also continued a form of domestic abuse against the mother in his interactions with her. I have considered above the likely behavior during the contact of the parent against whom findings are made and its effect on the child. I have considered the capacity of the father to appreciate the effect of past domestic abuse and found that he is resolute and has not taken any responsibility for his actions in a meaningful way. At the moment, that means that he is unlikely to be able to make changes at this time so that he could be in a position to co-parent in a positive way with the mother. The judge said that case law suggests that I consider the severity of the domestic abuse. The father argues it is minor and took place a long time ago, after which the parties reconciled. The mother would say that this is serious abuse and has had long-standing consequences. In my judgment, the focus of the court should be on the consequences of the abuse. The evidence is that the impact of the abusive relationship continues to impact the mother in a significant way. And this is only exacerbated by the father's continuing attitude towards the mother. It is not an attractive argument to have caused harm to the mother in the way I have found the father did, and then to criticize her for failing to be robust enough or failing to have found a way to recover herself so as to be in a position to deal with the abuser. My analysis so far is that the judge has set out the most cogent factors that a court should take into account in these types of situations. And I am hoping that the courts in Barbados would accept these considerations when faced with similar situations, having regard to the provisions under the Domestic Violence Act, which seem to include a child as a victim of domestic violence. The judge concluded at paragraphs 103 to 106, having regard to all of the evidence and for the reasons given above, I do not consider that to require the mother to make R, the child, available for direct contact with her father I do consider, that to require the mother R to make R available for direct contact with her father would expose her to a risk of harm that cannot be managed. They cannot co-parent. The mother's anxieties around contact with him and submitting her daughter to spend time with him would sustain, and the father has done nothing to show her that he can support her or reassure her so that her anxiety would lessen in future. For these reasons, I do not consider that supervised contact would be an effective means of managing the risk and would not reduce the potential for conflict. So the judge she's against even supervised contact in this case. She went on to say, I have had regard to R and her father's Article 8 rights to family life, which they have in the UK, and acknowledge that this does expose her to the risk of harm as a consequence of not having a relationship with her father. However, I am satisfied that the harm that would come to her as a result of making the orders is far greater. Further, it may yet prove possible for the relationship to be reestablished, but it must be after the father has been able to acknowledge the harm caused or demonstrate a willingness to change. In the first instance, by showing an understanding of the impact of his behavior on the mother and supporting rather than undermining her as a parent. Therapy or a domestic abuse perpetrator's course, as Mr. Kent suggests, might be a good start. Now, I don't know what is open to the courts in Barbados. If you have an attached social welfare department that deals with therapy or a course for domestic abuse perpetrators, I'm not sure, what exists in Barbados. I'm sure we'll hear maybe during the Q&A. The judge went on to say that I am satisfied that there are cogent reasons in this case to make orders that for the moment provide that R should not have direct contact with her father. I do not think that there are any options that could reasonably be pursued at this time, and consider that it is in the interest of all parties that this long-running litigation comes to an end. I do consider that R would benefit from having indirect contact with her father in the form of letters, cards, gifts on Christmas and birthdays. To an extent, I can understand why the father says there's no point in indirect contact if there's no plan to move it to direct contact. However, on the other hand, it could be argued, again, this is evidence of the father's position being that he wants contact with his daughter to be on his terms or not at all. So he is prepared to give it up. It's either all or nothing in this case. So in this case, the judge did not make an order for direct contact. I just want to refer to one other case. It's the case of Re H.N. and others. It's a case which concerned 4 appeals. It gives guidance on matters which generally arise in the family court and are of great importance. In particular, they address the issue of whether, where domestic abuse is alleged in proceedings affecting the welfare of children, the focus should be in some cases on pattern of behavior as opposed to specific incidents. So that domestic violence, as we all understood it at one time, was established when you could show specific incidents of domestic abuse. But I think the courts are now considering that where you have a pattern of behavior as opposed to specific incidents, that pattern could be established as a domestic violence offense. In this case, the H&N case, under the rubric of domestic violence at paragraph 23, the court dealt with the outdated approach in dealing with domestic violence under the old domestic violence legislation, the 1976 domestic violence legislation in the UK. It noted that it is wholly outdated and hard to comprehend an approach which required evidence of actual bodily harm to a victim before a power of arrest could have been attached to an injunction. Obsolete too is the approach seen in the 1980s, where judges regarded that violence was purely a matter between the adults and not a factor that would be ordinarily relevant to determining questions about the welfare of children. The UK courts have now shifted their approach to domestic violence. The Court of Appeal in this case accepted authoritative expert child psychiatric evidence that there needed to be a heightened awareness of the existence of and the consequences for children of exposure to domestic violence between parents and other partners. In its time, 20 years ago, the messages from REL led to a significant change in approach to domestic violence abuse allegations in the context of child welfare proceedings. So your Domestic Violence Protection Orders Act in Barbados provides for the protection of a child against child abuse. A person can now apply for a protection order for a child in Barbados. The police can grant an emergency protection order. The police have a duty to ensure the welfare and safety of children on the premises where domestic violence offense has been committed. And the police can, in determining whether to issue an emergency order for protection, they shall consider the welfare of any children residing with the perpetrator. There is no reason why the courts cannot use these sections to offer more protection to children in Barbados, thereby fulfilling the needs of the welfare principle, or the aspects of the relevant aspects of the welfare principle. As the present appeals illustrated, the H&N case, there are many cases in which the allegations are not of violence, but a pattern of behavior, which it is now understood to be abusive. This has led to an increasing recognition of the need in many cases for the court to focus on a pattern of behavior. The Practice Direction 12J came into force in the UK in 2010 and supplements their Family Proceedings Room Part 12, Family Proceedings Rules Part 12. I have attached this practice direction in the chat. I've attached the citation. And what I would like to say is that this is the type of direction our family courts need in order to gravitate towards, whether by amending the present Domestic Violence Protection Orders Act or by making similar rules, a similar type of practice direction, perhaps in Barbados. Paragraph 26 of this case, the H&N case, refers to Practice Direction 12J, and paragraph 3 includes the following definitions, of which it should be noted refer to a pattern of acts or incidents. So domestic abuse under the practice direction includes any incident or pattern of incidents of controlling, coercive, or threatening behavior, violence or abuse between those aged 16 or over who are or have been intimate partners or family members, regardless of gender or sexuality. This can encompass, but is not limited to, psychological, physical, sexual, financial, or emotional abuse. Domestic abuse also includes culturally specific forms of abuse, including, but not limited to, forced marriage, honor-based violence, dowry-related abuse, and transnational marriage abandonment. Coercive behavior means an act or a pattern of acts of assault, threats, humiliation, and intimidation, or other abuse that is used to harm, punish, or frighten the victim. Controlling behavior means an act or pattern of acts designed to make a person subordinate and or dependent by isolating them from sources of support, exploiting their resources and capacities for personal gain, depriving them of the means needed for independence, resistance, escape, and regulating their everyday behavior. So it is now accepted without reservation that it is possible to be a victim of controlling or coercive or threatening behavior without ever sustaining a physical injury. Importantly, it is now also understood that specific incidents, rather than being seen as freestanding matters, may be part of a wider pattern of abuse or controlling or coercive behavior. So that brings me to the end of my presentation, and I sincerely hope that given the fact that your domestic violence legislation has the necessary underpinnings to protect children, that your judiciary and you as family law advocates will encourage the court to use all of its powers to protect children and, of course, to promote the welfare principle. So I thank you very much for your listening attention.
Thank you, ladies. And we would like to open up the floor for any questions. Again, feel free to unmute your mic, use the reaction button to raise your hand, or to pop them in the chat. And these ladies, as you can see, are a total wealth of knowledge. So I hope you will take them up on mining any more that you thought of during the presentation.
Robin, hi, good evening to everybody. I just kind of want to, I know of course you're gonna do the formal thank you, but in warming up the floor and kind of opening up the space, I wanted to thank our two colleagues from Trinidad for giving us some perspective. You know, we've watched on over the years as Trinidad has tried to grapple with their own issues and make a safer space for women and girls and children more broadly. I'm fascinated with some of the things that have happened in their space over the last couple of years. And I know it's by no means perfect, but at least what they're doing is trying to address the situation, and that's laudable. I once had a case where a mother was murdered. The mother shared a daughter with the person who murdered her. And I saw a particular part of the protection orders used to grant the paternal grandmother of that child access to the child on the weekend. And now the child she was about 4 or 5 when the incident happened. She's now about 10 or 11. And she recently had to start counseling because of, you know, having to go by her grandmother and family members constantly trying to explain from her father's perspective what happened and why he did it and so on and so forth. And I just wondered if any of our two colleagues from Trinidad had ever come across or experienced a case like that, where there's loss of a parent, and then what are the rights left over, for the lack of a better word, for the family of the person who would have committed the murder.
Devi, you want to go? You want to answer?
Yeah,
I'll add a few. Yeah.
Sure. I have never had a case of a murder, but I had a case where a woman a mother had her arm chopped off at the hands of course, of her partner. You know, and it was done, actually the act of violence was done in the presence of the child. So the mother, obviously in that case, the mother was vested with custody, care, and control, and access to the father was, cut off completely. I know that in that case, there was subsequent proceedings where an aunt, a paternal aunt, made a request for access, some kind of access. I believe it was holiday access, and it was also refused. I know the attorney who represented the aunt, and I know that in those circumstances, the judge indicated that the judge could not be certain that there would not be an attempt to influence the child, and that was a large part of why the order for contact with the paternal aunt was refused. But that has been my only experience with that level of violence, which of course does not include the death of a parent. So.
I must say I've never had that kind of scenario to deal with, Marsha. I haven't, but all I can say is that under our legislation, our Family Law Act, I mean, a stranger could apply for custody of a child. So I guess in that kind of scenario, a grandparent would be entitled to apply for custody of a child, if that happened, the paternal grandparent or maternal grandparent.
Thank you. And I will also, there are a couple of questions in the chat. The first is from Jolie Gabriel, and it says, what if one parent lives abroad while the other lives in Barbados or Trinidad?
Could she explain the circumstance a little more, the scenario? I'm not sure I'm getting it. You mean is that for access? Jolie, could you unmute and maybe you can tell us?
Yeah, so I mean it in the terms of access. Say if it's a very recent birth of a child and the child is still young, and the mother came back here and the father lived with something. So what happens in that instance where they don't live in the same country? Okay.
So you can, I mean, in terms of access, a court should give access, whether it is, if it's a very young child, the mother takes the child to visit the father if the father lives in another country, or the father is allowed to visit the child in the country where, the child resides with its mother. That is the type, I've had situations like that where those types of arrangements have been made. As to who pays the cost of the airfare, etc., that's always a bone of contention, but it can be worked out like that.
If I may add to that, I have a circumstance where an order was made in Barbados. A father presented a divorce in Barbados. He's not Barbadian. He's actually from St. Vincent, but was living and working in Barbados. The parties were living and working in Barbados. Marriage broke down, and the mother returned to Trinidad with the one child. Father presented the divorce in Barbados and obtained, in the mother's absence or non-participation in the Barbadian proceedings, an order for shared custody, and an order that the father would have access. It was a 2-year-old child at the time, would have access wherever he was, and gave very specific terms. I found that, I made a jurisdictional argument in Trinidad, and, the proceedings are still ongoing. However, I found it peculiar that an order for access would have been made in those terms, because in Trinidad, we generally include in our access orders, if parties are living in different countries, the circumstances under which those access arrangements would be engaged. So we normally would include that, the father, if he's moving, that we have to be alerted as to the provisions in the home where the child would be housed. If he's continuing to work, whether there would be arrangements made for a childcare provider during his working hours, and whether, how the child would be delivered to him, and how, who would pay for that kind of thing. So I was a little concerned that the order just appeared to give him access wherever he was without making that kind of arrangement, particularly in circumstances where there was no good communication between mother and father, so that the negotiation to make those arrangements was impossible. So I think it, even in those circumstances where you have that transnational kind of arrangement, I think it's important for the courts to consider that more defined arrangements should be put in place. Yeah.
Thank you, Devi. We have another question in the chat from Jepter, which says, what would it take for the court to prevent an abusive parent short of removing the arm of the partner from seeing a child?
I'm reading the question in the chat, and I'm not sure I understand it. I don't know whether Jepta could just elaborate a bit on the question.
Good evening. You indicated just now that you had a case with a partner who was prevented from seeing his child because he had attacked his partner. A parent had attacked his partner and removed her arm. So I'm asking you, where violence is so blatant and so obvious, yes, I can see the court ordering that individual not see the child, but anything short of that, is there any other occasion where the court might be minded to prevent a parent who has not shown that kind of abuse but still is abusive? That's what I want.
I think the court can take into account there are situations where, for example, if the parent seeking access is a drug addict, recovering drug addict, or has a criminal record, those are certainly circumstances that the court can consider in preventing access or direct contact to a child, by a parent. So I think those would be circumstances certainly that the court could take into account, other than there's open abuse.
I also had a circumstance where a parent was diagnosed with bipolar disorder, and their experiences of extreme highs and extreme lows. During the periods of the extreme highs, they tended to be very hyper and often had engaged in verbal abuse and emotional abuse of their partner. In those circumstances where the mother refused to participate in drug therapy, which would have modified her behavior, the court actually determined that until she engaged in an appropriate program, that she would be deprived of access. So I think this also plays into the Joan's indications or presentation about pattern of behavior that is being given now a lot of credence by the courts. If we can demonstrate where there is no actual violence, but there is a pattern of controlling or coercive behavior that is likely to affect the welfare of the child, then that is a relevant consideration to the court. And although it may not be sufficient to curtail access altogether, it may be enough reason to limit access, or maybe even have a supervisory order.
Chapter, does that answers your question?
Yes, it does. Thanks. Yes.
Okay, we also have a comment from Nyla that says, I heard mention of the fact that there do not seem to be many supervised access orders in Barbados. I think that here the supervised access normally occurs where the parent has abused the child. I think in situations of domestic abuse between parents, the more common arrangement is for a third party to manage the handover of the child. And Talal follows on to that, saying that I've had orders for supervised access where no violence was affected on parties to a marriage or the children, but where drug use was simply alleged and confirmed later during proceedings. And where domestic violence was established by exhibition protection orders to affidavits.
I think the comment concerning the third party to manage the handover of the child, that is quite common in Trinidad. The courts here would tend to have that type of arrangement, particularly in cases where there is an abusive relationship between the parents of the child. So that is quite common here.
Also common in Trinidad is orders that made for supervision where parties have been threatening, but so there's no actual physical violence, but there's a threat of violence coupled with the possession of the perpetrator of a firearm. So we have different arrangements that are made for those kinds of things where the father is made to surrender, or the perpetrator is made to surrender the firearm, etc. So that I think what we're trying to establish is not, I don't think we've actually said that the supervision orders are not made with sufficient regularity in Barbados. But I think we're trying to indicate, as pursuant to the welfare principles as well, that the court must make use of the wide ambit of available orders to secure the welfare of the child.
And I would also like to ask a question here following Nyla's comments, as she mentioned that where the only time we have supervised access, well, most of the time supervised access is done on the basis where there is direct abuse to the child. I assume that is physical, but where there is confirmed abuse between the parents, how does the welfare principle take that? How does the welfare principle separate those two instances, as we have said that, you know, a child in an abusive environment or who has witnessed abuse is therefore also abused or has the potential to experience abuse?
Well, I think both your Domestic Violence Amendment Act as well as our Domestic Violence Amendment, our Domestic Violence Act has been recently substantially amended. And both pieces of legislation do now acknowledge that a child witnessing violence, that is in itself a domestic violence offense. So if we look to the welfare principles as to be implemented, its use or its expansion to treat with issues of custody and access in particular, then if you can establish that there has been a domestic violence offense, certainly I think it would merit a judge considering that it would not be in the best interest of a child to be with the perpetrator of that domestic violence offense, which is the simple witnessing of domestic violence. I don't know if that answers your question, Robin.
Yes, it does. Thank you. It is now 7:30, so if there are no more other questions for Devi and Joan, we will go ahead and get wrapped up.
Hi, this is Talal. Just to drop a comment to Joan. Joan earlier mentioned that whether there's any kind of facilitation through whatever agency as it relates to the protection orders in Barbados through the police. Now, Barbados does have the Family Victims Unit, which I believe that they have two who are head of it. I believe, I could be wrong, but those two take care of 300,000 people in Barbados. It's kind of absolutely useless. If you ask me, I think we need more manpower, and I keep saying we need to keep sensitizing the police and the magistracy and all of the whole hoopla. And I say that knowing that everybody would agree with me. That's all I have to say.
Agreed. Yes.
Valid comment. Yes.
Thank you so much, Talal. I also want to echo Marcia's comments to Devi and Joan, and I do want to say that the honor is most certainly ours for having accepted our invitation and for having given selflessly of your time and expertise this evening. To the participants, thank you so much again for joining us this evening, and I hope you are also looking forward to next week's sessions. On Tuesday, we have the importance of expert reports, which both Devi and Joan alluded to in their presentations. And then on Thursday, we talk about building a case management team and a more client-centered approach. So that's all for this evening, folks. Thank you so much.
Thank you. Thank you very much.
Bye.
Good night, everyone.
Good night.
Thank you. Good night.